Good evening. We're going to call the 7:30 hearing to order for the Board of Appeals. My name is Frank O'Brien. I'm the acting chair for this meeting. To my right is Board Member Virginia Donahue King, and to my left is Board Member Nicholas Gray. Our 7:30 hearing this evening is on the application of Jane Page and Gregory Christensen, the applicants of 97 Valley Parkway, dated January 9th, 2017, on file with the Board of Appeals for a variance/special permit from the terms of Section 6A7 and Section 4 of the Milton zoning bylaw. The applicants propose to internally subdivide lots number 3 and number 2 at 97 Neponset Valley Parkway and 101 Neponset Valley Parkway, Milton, to make lot number 2 contain 42,177.5 square feet instead of the current 45,445 square feet, and lot 3 to have 61,874 square feet instead of the current 58,515 square feet, to cure an encroachment of a part of a septic system which serves 97 Neponset Valley Parkway. Section 6A7 of the Milton zoning bylaw requires 80,000 square feet of land and 150 feet of frontage. The homes were built in 1958, so they are considered pre-existing non-conforming. The property is located in a Residence AA zoning district. All is therein set forth in said application and plans on file with the board and open to public inspection. Also included in our file this evening is the application for the relief to the Board of Appeals, a letter from our town building inspector noting the difficulties with the request and suggesting that an appeal to the Board of Appeals was needed. A helpful memorandum for Marion McKettrick, an attorney in Milton who appears frequently before the board, as well as a plan of land by D. O'Brien Land Surveying, entitled 97-101 Neponset Valley Parkway, dated October 30th, 2016. As well as a subdivision plan which looks like it's out of the land court, the Registry of Deeds. So we will have that all as part of the evidence for this evening's proceedings. The rules of the board are such that we will first hear from the applicant. Following the applicant's presentation, if there are any members of the audience who wish to ask questions of the board or to express opinions concerning the application, we'll hear them then. With that, Mrs. McKettrick, welcome back to the Board of Appeals.
Thank you very much. And I am Mary McKettrick, here to represent both applicants on both sides of the lot line. But for this first application,
Let me stop you for just a second for the sake of the applicants here, my fellow board members and the folks who may be watching this. We have two related applications. For the sake of simplicity and to make sure that we're fully compliant with the open meeting law, we're going to take them in succession as if they were two separate applications. They aren't. They're related. So there may be a bit of redundancy, but doing so makes sure that everybody has a full and fair opportunity and we're all copacetic with the requirements of the open meeting law. So, Mrs. McKettrick, sorry for the interruption. Thank you. Please proceed.
exactly. So this first application, I believe, is the one on behalf of James Page and Gregory Christensen. That's what you just read, I believe. And actually, this is the lot that has the problem, because this lot has a septic system that's encroaching on their neighbor's lot. And it's an older septic system. The lots were created in the late 1950s. This is registered land, so there are land plans recorded at the time of the subdivision. And when the septic system was put in, Presumably, there was an error made. It's possible there were related parties living on each lot, but in any case, the situation as it presently exists is not a good one, because the septic system for one lot is partially on the other lot. So these neighbors seem to be getting along well, and they have reached an agreement to convey a portion of land from the neighbor's lot to James Page and Gregory Christensen, so that they will have a septic system that will, if this works, will be entirely on their own lot. In order to do that, they have to first have a plan drawn, which they have done, for a new, what I call a parcel of land, because it's not a buildable lot, and showing the new lot lines for each of the prior existing lots. This is registered land, so this plan will have to be approved by the land court. Even though it's just to create one parcel, a new plan will have to be recorded, and it'll have to be in the proper form. But the first step is to come to you at the Board of Appeals. And the reason for this is that each of these existing lots is a pre-existing non-conforming lot, because when they were created, Milton did not have AA zoning. So these lots were not created as 2-acre lots. They are less than 2 acres, each of them, and they have legal status because they were in existence when we changed the bylaw and created AA zoning and required 80,000 square feet. But these lots are in an area that has septic systems. That was the reason for the AA zoning. So what we're asking you to do tonight is to approve a change in each of these pre-existing non-conforming lots. In one case, the lot will be made larger, but it still won't be 80,000 square feet. In the other case, the lot will be made smaller and will not be 80,000 square feet. So these new lots require your approval, and that could be done through a special permit application under Section 4 of the bylaw. But we are also asking you to consider granting a variance, because if you grant a variance to make this change, the lot will have fully legal status, and they'll be able to make changes in their house on the lot without coming back to the Board of Appeals for a special permit in more cases than you would normally if you had to make such a change. It's a little complicated. I've discussed this with the building commissioner, and his view, as well as my view, is that it would be a good thing if you would grant a variance, if you're willing to do that, because then the applicants would be pretty much in the same position they are now in terms of what they can do with structures on their existing lots. There are, I don't know what else I need to have the applicants tell you, but certainly if you have questions for them, they can answer them. There is going to be a conveyance in the future if you approve this, and there is going to be a purchase price for the piece of land that's going to be conveyed. After I do this, if you approve either a special permit or a variance, I believe we have to go to the planning board to get an A&R approval not required, because this is not a subdivision stamp on this plan. And then once we ensure that the plan is in proper form for land court, it has to go to land court and be approved by land court. So, and then finally, the conveyance can take place. So there are a number of steps. It's a little complicated. You might ask, since you're all attorneys, why aren't you doing an easement instead of a conveyance? We talked about that, but the parties feel that they would like to have the lot line settled, and they would prefer to do it this way if they can. That's the story.
Okay. Questions?
Well, I figured I'll ask just the one question, which is just so it's on the record and there's an answer for it. There's a lot of work to go through to, obviously, to get the slice. Would it be easier to just move the septic system? And there's probably a good answer to that, and that's why I thought especially if it were old.
It's a good question. I actually talked to a few people about this because it's an interesting case, and that's one of the questions that have come up. And I think Mr. Christensen probably should answer it. I will say this, that having dealt with a few septic systems in Milton and new septic systems, it is an enormously expensive endeavor, and you have to find the right place for the septic system. Right. So that's part of the answer, but maybe you'd like to add to that.
Yeah, that's really our fear, is trying to find another spot on the lot that would be appropriate for the leaching field. The leaching field, as it is now, is actually a leaching mound, because there is a high water table in that part of town in general. I mean, we're at the foothills of the Blue Hills, and so the water's trying to make its way to the Neponset feeders. And so I would be very nervous about trying to find another piece of, I mean, I'm sure there could be, but we don't know that. If we went down that route, whether or not we'd find an acceptable place for the leaching. So in our mind, this seems like a simpler solution. We know what we're getting into if this works. If not, there's a lot of unknown. It kind of scares us, to be honest.
Okay, I get it. Were there any neighbors that had any comments on it or anything, that in advance, that, has anyone spoken to the abutters or had any issue with it?
No, I mean, they were notified, I believe.
Yeah,
We didn't hear-
the butters, if you were to go to this site, you'd see that the houses are quite spread out. There are
Yeah.
only a few of them. One of them is on the corner, and the next house, of course, is the other party's house. There's nothing across the street. It's a pretty busy street. I wouldn't even have expected, you never can tell, but we've had no feedback from
Okay.
anybody indicating opposition, so.
That's all I have.
Mrs. King?
Again, this is kind of for the record. Had you thought at all about doing some kind of a land swap so that the square footage of the lots would remain the same, or is that something that, for one reason or another, might be impossible or not?
It was
idea.
brought up at one time. Again, I'm sure it could be done. There was no logical place to swap the land. Part of the reason why we came up with this slice is to get it 10 feet away from the leaching area. And we carried it back down to the front property line along the Ponce Valley Parkway. If you were to see the site, there's a natural barrier of trees right along that line, and that's kind of why we always assumed that's where the property line was until we had it surveyed. There's old growth trees, and there's actually a drop-off in grade and a swale that had been put there a long, long time ago, I think to control drainage. And so, if we were going to swap any land in the front property, I think it's going to get us too close to our house. We're already, the property line as it is surprisingly close to the structure. I would be nervous about bringing it, closer. That would then look at maybe the back of the property, so to take a chunk out of the middle. I mean, I guess it could be done.
A little odd shape, though.
But yeah, it would be kind of awkward, and I don't know if it would be any beneficial use to the owner of that lot, as much as maybe it would solve some problems in the square footage of, on your end. I mean, I don't know how you view the size of these lots being non-conforming, but maybe if that was something you required, we could figure out how to do it. But it doesn't make a lot of sense for either user.
Okay, thank you.
Well, just a couple of questions to kind of wrap it up. So if I hear you correctly, the size and dimensions of the lot, a little bit more than a map-making exercise. It is, takes into account the natural contours of the land. You said that there's a line of old-growth trees that's kind of like a natural visual barrier.
Yeah, if you see that new angle of that little pie, that's kind of where all those big growth trees are, and on both sides it's clear and landscaped. And also right along that, I think why the trees have grown there for so long is because they, at one point, had graded the lot. So it steps down, and then they had made a little bit of a swale. It's kind of filled in over the years, but it follows almost identical. So if you were to see the lot, that's most logical place for having that new division. It's kind of land that neither property is using. It's just kind of a wooded line.
All right, thank you. Mrs. McKettrick, now we're going to get into the if you will, sort of technical discussion. So we've got three options here. We've got a variance, we've got a special permit, and we've got a variance and special permit combo platter. So, generally speaking, and I'm just talking hypothetically here, in a situation such as this, the board would oftentimes opt for the combo platter with a special permit and variance, because you do have a non-conforming use under Section 4. though you could make an argument that it's not really non-conforming because it's a residential structure, but it is a significant deviation from the bylaw in terms of the area. So I have that in mind. Variance works because concerning the size of the lot. I'm not unsympathetic to the desire of either landowner to retain the maximum amount of control in terms of a variance and not having to come back to the Board of Appeals for additional changes to the lot. So your preference, just to put it on the record absolutely clear, is for a single variance from the provisions of 6A7, correct?
I believe that's the correct section that should be in here. But I'll check that for you. But anyway, yes. Well, we discussed this quite a bit, but because there was a change in the law this year giving, it's kind of a subtle relationship because it wasn't strictly speaking for variances. The effect of the legal change, the statutory change this year that's expected is that it will now become true that if you have a variance for a lot that's undersized or something like that, that will now, you will be able to make changes to structures on the lot just as you would if you had a legal lot. And that will also be true of lots that were, of structures that were not legal at the time they were put in place, but have become legal because of the passage of time and because there hasn't been any enforcement. It has nothing to do really with this immediate application, but it's expected to have that effect. So in looking at this case, I thought that it would be preferable to provide the variance in case that advantage proved to be true because of this change. I don't have any objection to you. I certainly wouldn't object to the smorgasbord approach if you'd like to grant both. Normally, I would ask for that if I thought there were a possibility, and there always is, I suppose, of an appeal, because I think that the special permit is easier to defend because the standard is not quite as difficult as the standard for variance. And there's clearly a provision in the bylaw for doing this by special permit. So if you wanted to grant both, we wouldn't certainly object, but it's the variance that I'm particularly concerned about getting.
I'm a little, frankly,
Sorry.
I'm a little uncomfortable with just going the variance route alone. I think that in this particular case, the applicant has made the case for hardship, but I haven't heard a lot about some of the other aspects that we traditionally base a variance on. A little bit about, the geographic structure of the land, somewhat unique, but maybe not, but a little uncomfortable there. But let me ask my fellow board members if you guys have any of those concerns that I may have articulated.
I think you said it pretty well.
All right. Do you have anything else that you would like
I
to
don't.
add?
I mean, we came here hoping that you would grant a variance and special permit. If you're willing to do that, that would be great. If you're not, we would probably proceed with the special permit. And I've tried to explain why I thought the variance might be advantageous here, at least for the applicants. I understand the standard. I think I referred to it myself.
Yes.
It can be difficult to meet. Here, I don't think there's any harm to any neighbor. This is really just something that's being done to correct an error in the far past. And it's important to correct it in some way. So if you're willing to give us some remedy, we'd be very happy with that.
All right. Have you finished your presentation?
I have.
Okay. Is there anyone else in the audience who wishes to? In hearing none, we'll close the evidentiary portion of the hearing. And under the open meeting law, we're obliged to discuss your case and render a decision here and now, and we will do just that. Mr. Gray.
Thank you. It's an interesting little problem. I'm certainly sympathetic to the fact that it's a problem in need of a solution. Doesn't seem to have generated a ton of opposition or support one way or the other. I think it makes sense to try to regularize the situation if we can. And I guess I would, subject to listening to what my colleagues have to say, I would be, all things considered, intend to vote in favor of providing some relief one way or another.
Okay.
As would I. This is a difficult situation, and I think you've been able to find a good solution that will work for the neighborhood. I don't see that there's anybody else that will be affected by this at all, really, in as much as that they were pre-existing homes before the change in the requirements for having 80,000 square feet. So I would certainly be voting in favor of relief. The kind of relief, I see no harm in granting both. I think there's a lot of merit to granting both. It makes both homeowners comfortable with the situation that they have. They know what their responsibilities are with the land and so forth. And because they're pre-existing homes and a pre-existing leach field, which for whatever reason was cited improperly, there's nobody alive that can talk about that now, I'm quite sure. So I would like to give the maximum amount of protection for the homeowners as we can. So that's my tendency. That's my thought.
Thank you. I too thank you for an excellent presentation, as always. And I'm inclined to grant relief and in the form of a variance and special permit. So unless somebody has anything else they'd like to add, why don't we take a vote? All those in favor of granting relief requested in form of a special permit and variance, say aye.
Aye.
Aye. There you have it.
Thank you.
Your special permit and variance is granted on this particular one, which is
97.
97.
Go through the next one.
So, seeing as how we are have the same applicants and the same issue, why don't we move right into the 7:45 hearing, and let me get those preliminaries done, and maybe we can have an expedited hearing on this particular one as well. So we will now begin our 7:45 hearing. Get the right file. This is upon the application of Tracy Lawless, the applicant of 101 Defensive Valley Parkway, dated January 9th, 2017, on file with the Board of Appeals for a variance special permit from the terms of Section 6A7 and Section 4 of the Milton zoning bylaw. The applicants proposed to internally subdivide lots 3 and 2 at 97 Neponset Valley Parkway and 101 Neponset Valley Parkway, Milton, respectively, to make Lot 2 contain 42,177 square feet instead of the current 45,545 square feet, and Lot 3 to have 61,874 square feet instead of the current 58,515 square feet to cure an encroachment of a part of a septic system which serves 97 Neponset Valley Parkway. Section 6A7 of Milton zoning bylaw requires 80,000 square feet of land and 150 feet of frontage. These homes were built in 1958, so they are considered pre-existing non-conforming. The property is located in a residence AA zoning district. All is therein set forth in said application and plans on file with the board and open to public inspection. My name is Francis O'Brien. I'm the acting chairman for this hearing. Excuse me. To my right is Virginia Donahue King, and to my left is Nicholas Gray, who are board members. Also included in the package for this file is the application, a denial letter from Joseph Prondak, the Milton Building Commissioner, a helpful memorandum from Mary McKettrick, attorney at law of Milton, who represents the applicant in this particular issue, a plot plan of the land in question, as well as a subdivision plan of the land. The rules of the board are such that we will first hear from the applicant, and then we'll hear from anyone in the audience who has any questions for the applicant or wishes to put anything else on the record. And with that, Mrs. McKettrick, the floor is yours.
So I'm here representing Tracy Lawless. She is the neighbor who is trying to help a neighbor. So she owns a lot next to James Page and Gregory Christensen. They found that their septic system encroaches on her lot, and they have asked her whether she would be willing to convey a portion of her lot to them so that their septic system will be entirely on a lot that they own. And we've had considerable discussion about the approach, but in the end, after discussing this with the building commissioner, we've determined these are two pre-existing non-conforming lots. They can't make this change without getting approval from the Board of Appeals, because you can't make a pre-existing non-conforming lot even smaller than the required area without either receiving a variance or a special permit under Section 4 of the bylaw. So we're applying for both. And in this case, I can't really point to a benefit to Tracy Lawless. She's being accommodating here. She'll receive some compensation for this conveyance, but basically it's some trouble for her. But she's willing, and so far has been very helpful, to help her neighbors and to clear this situation up. So we've, explored a number of reasons why the applicants decided not to do this through an easement, because they wanted to have the lot lines settled, and they wanted their lots separate for future conveyance purposes and not having to worry about any kind of easement for the septic system. They have created a new lot line that is along a natural separation of the two lots. There are old-growth trees along the lot line, and there's also sort of a swale and a slight change in grade marking this separation. So it's kind of a natural place to separate the lots. And it almost looks as if this is what everybody thought the lot line was, and that may be one reason, or survey error, that this happened. In any case, we're asking for relief from the Board of Appeals, either in the form or in the form of both a variance and special permit, and we're happy to answer questions.
Thank you. Just for the record, the board held a public hearing earlier this evening granting the relief requested for the related lot. So this is the second case of the evening. With that, let me ask my fellow board members if they have any questions. Mrs. King.
Well, if I had questions, that would be very odd, don't you think?
Mr. Gray.
No no further questions from the last
I do
hearing.
not have any questions myself. With that, let me ask if anyone in the audience has any questions. Seeing none, we'll close the evidentiary portion of this hearing and proceed to deliberation. Under the open meeting law, the board is required to deliberate in public, and we'll do that here and now. And Mrs. King.
Well, this isn't my reasoning for saying yes, but it would, again, be very odd if we granted one to Mr. Christensen and not to Mrs. Lawless. No, I think that, as before, this makes a lot of sense for both parties, and I'm all for granting a special permit and a variance.
Mr. King.
It's all
Mr.
right.
King.
I agree.
No, he's home.
One wife's enough. I agree. Thank you very much.
And I agree as well. And with that, let me ask those in favor of providing the relief granted in the form of a special permit and variance signify by saying aye.
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 Congratulations. The
Thank you.
relief is granted. I will spare you the usual speech about
Recording.
appeals and having to record it in the registry, having known that you probably know more about that than I do. So with that, Mrs. Lawless, thank you for, it's nice to have a couple people come before the Board of Appeals who have worked things out in a neighborly fashion. And I congratulate you for doing that. Sad to say, but it's it is something that needs congratulating. So,
Should be that.
yeah, exactly, but sometimes it isn't. With that, Mrs. McKettrick, thank you as always, and we appreciate it. With that, this hearing is adjourned. Thanks, guys.
Thank you very much, guys.
All right. One of the prerogatives of the chairman is I get to assign it.